Welcome back to the deep dive. Today, we're stepping into a legal arena where two massive tectonic plates of the law collide. On one side, you've got freedom of contract, the idea that you and I, as consenting adults, can agree to pretty much anything we want.
Right.
And on the other side, you have public policy, the things that society just says, no, absolutely not. You cannot do that.
It is the classic tension, isn't it? Individual autonomy versus, the collective good.
Exactly. And usually, freedom of contract wins. But today, we are looking at where that line is drawn. And to get us into the right mindset, I want you to imagine a scenario. Let's say you have a business partner.
Okay.
And this partner didn't just make a mistake. They cheated you. They lied, they cut corners, and it cost you a lot of money. Now, you're angry.
Understandably.
You don't just want your money back. You want to punish them. You want to teach them a lesson they will never forget.
Which is a very human reaction. You want retribution?
Right. So you have a contract that says if there's a dispute, you go to a private judge, an arbitrator. And you want that arbitrator to just slam your partner with a massive fine way above what you actually lost, just to make them suffer. Can you just do that?
That is the central question we're tackling today. And the answer, well, it takes us into something called a state monopoly on punishment.
Ooh, state monopoly on punishment. That sounds intense.
It is. This deep dive is focused squarely on the limitations of arbitration and contract law. We're going to map out three key areas.
Okay.
First, we will examine that very concept of the state monopoly. Second, we'll dissect the danger of what the law calls uncontrolled coercive economic sanctions.
Okay.
And finally, we will analyze the landmark New York case that drew this line in the sand, Garrity v. Stuart.
Okay, let's unpack this. Why can't two consenting adults agree in a contract that if one of them breaks the rules, the other gets to punish them? I mean, if I sign a piece of paper saying, if I'm late, you can fine me $1 million, why shouldn't that be valid? I agreed to it.
To understand why not, we have to look at the general rule regarding punitive damages in arbitration. And the rule is actually quite stark.
Okay.
Punitive damages are a sanction reserved strictly for the state.
Reserved strictly for the state.
Correct. The rule has three distinct elements we need to keep in mind. First, punishment is a monopoly of the sovereign power, that is, the state. Second, the law does not permit private persons to submit themselves to punitive sanctions. And third, and this is the key phrase, freedom of contract does not embrace the freedom to punish.
Freedom of contract does not embrace the freedom to punish. That is a powerful phrase. But why? Is it just the government wanting to keep all the power for itself?
Well, it goes deeper than that. The source material for this deep dive references the legal philosopher Hans Kelsen.
Okay.
And the argument is that one of the fundamental purposes of the rule of law is to require that the use of coercion be controlled by the state.
Controlled coercion. So the idea is we don't want vigilante justice.
Precisely. In a, primitive society, if you wronged me, I might just come burn down your barn. That's private punishment.
Right.
The state was invented, in part, to stop that cycle. We outsourced violence and punishment to the government.
Okay, that makes sense for physical violence. We don't want people running their own private prisons. But in a developed economy, we're usually talking about money, not fists.
True, but the principle holds. The source material points out that in a modern commercial society, the danger is the uncontrolled use of coercive economic sanctions in private arrangements.
I see. So if we allow private punishment, we are basically letting wealthy or powerful people run their own private court systems with their own private fines.
Exactly. It creates a parallel legal system without any of the safeguards of the public courts. You're essentially privatizing the penal code, letting individuals wield the power of the sovereign against each other.
Let's test the limits of this with a visceral hypothetical. I really want to see where this breaks down.
Go for it.
Okay, imagine a wealthy, eccentric billionaire, let's call him Mr. Big, and he hires a struggling author to write his biography. The author is desperate for cash. So, Mr. Big puts a clause in the contract that says, if you miss your deadline by even 1 hour, not only do you lose your fee, but I, the billionaire, get to fine you $1 million for my emotional satisfaction to teach you a lesson about punctuality.
Wow, a classic contract of adhesion, signed out of desperation.
Right, but the author signs it, they consented, they're a competent adult. If the author is late, can the billionaire enforce that $1 million fine?
If we apply the logic from our source material, the answer is a resounding no.
No.
Even if the author signed this desperate deal, the law views this kind of arrangement as, well, barbaric.
Barbaric. That is a strong word for a contract dispute.
It is the word used in the legal theory around this. The source text explicitly notes, "The day is long past since barbaric man achieved redress by private punitive measures." The law sees essentially no difference between Mr. Big physically harming the author and Mr. Big fining the author $1,000,000 simply to teach him a lesson. Both are private individuals wielding power that belongs only to the sovereign.
Wow. So we've evolved past the point of an eye for an eye in private contracts.
Exactly. Allowing Mr. Big to levy that fine would be a violation of strong public policy. It would be comparable to allowing private citizens to run their own penal system. You cannot contract away the state's monopoly on punishment, no matter how much you agree to it.
That makes the stakes very clear. This isn't just about money, it's about who has the right to wield power in society. Okay, let's move from my made-up billionaire to the actual controlling case to see how real court handled this.
This brings us to Garrity v. Stuart, decided by the Court of Appeals of New York in 1976. This is really the case that solidified this doctrine.
Let's analyze Garrity v. Stuart. First, what are the legally dispositive facts?
Okay, so the plaintiff was Joan Garrity, an author. The defendant was Lyle Stewart, Inc., a publishing company. And the dispute arose when Garrity brought a proceeding to confirm an arbitration award against the publisher for breach of contract.
And what was the payout? What did the arbitrator actually award her?
The arbitrator awarded two things. First, $45,000 in compensatory damages. That's for the actual loss she suffered. And second, the arbitrator also awarded $7,500 in punitive damages.
Okay, so there it is. And how did the lower courts handle this before it got to the highest court?
Well, interestingly, the lower courts, the Supreme Court and the Appellate Division, they actually confirmed the award. They said it was fine.
Really?
Yes, but there was a dissent in the Appellate Division, which is what set the stage for this appeal to the highest court.
Okay, so the lower courts were okay with the arbitrator punishing the publisher, but the high court took a different view. So what was the core legal issue?
The issue was this. Does an arbitrator have the power to award punitive damages, even if the parties seemingly agreed to the whole arbitration process?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied what we can call the public policy exception to arbitration powers. This rule can be broken down into three key elements.
Okay.
Element 1 concerns the nature of the sanction. Punitive damages are a state sanction, not a private remedy.
Got it.
Element 2 is about the scope of power. An arbitrator has no power to award punitive damages, regardless of what the parties agreed to.
Right.
And element 3 concerns judicial intrusion. The court must step in and vacate the award when it violates a strong public policy.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the nature of the sanction?
Well, the sub-issue here is really, is a punitive award a civil remedy, or is it a social punishment?
A private fix versus a public example.
Exactly. The court reasoned that the enforcement of punitive damages is a social exemplar that's reserved for the state.
A social exemplar.
Yes. It means its purpose isn't to fix a private wrong, but to make an example out of someone for the benefit of all of society.
I see.
The court noted that the $45,000 was for making the victim whole. That's a private remedy. But the $7,500 was explicitly labeled punitive. So its only purpose was to punish the wrongdoer, not to compensate the victim. So that first element was clearly met. This was a penal sanction.
Understood. It is about the label and the intent. Now, what about the second element, the scope of the arbitrator's power?
The sub-issue there is, can the parties expand an arbitrator's power to include punishment just by using their contract?
Right. Can they just write it in?
And the court stated unequivocally that freedom of contract does not embrace the freedom to punish, even by contract.
Even if they wrote it down in big, bold letters?
Even then. The court noted that in this specific case, the parties didn't even specifically agree to punitive damages in their contract. But the court went further. It said even if they had agreed to it, it wouldn't matter. The conclusion for this element was that the arbitrator exceeded their power because private parties cannot grant the power to punish to a third party. It's just a power they don't possess to give away.
That is a crucial distinction. You can't give an arbitrator a power that you don't have yourself.
Exactly.
So the third element, the necessity of judicial intrusion.
Right. So the sub-issue is, should the court respect the arbitration award or should it interfere? And the general rule is that courts hate interfering with arbitration.
Right. The whole point of arbitration is to stay out of court.
Correct. But here, the court held that punitive damages are a public policy of such magnitude that it actually calls for judicial intrusion.
It's an exception to the rule.
A major one. They argued that to enforce an award like this would violate the basic traditions of the rule of law. So the conclusion on this element was that the court is effectively required to step in. They have to stop the enforcement of the punitive part. They can't just turn a blind eye to a private penal system.
And after analyzing all the elements, what was the court's final conclusion?
The Court of Appeals modified the order. They upheld the $45,000 in compensatory damages. So Garrity got the money for her actual loss.
So she was made whole.
Yes, but they vacated or threw out the $7,500 punitive damages award.
So the publisher didn't get punished by the arbitrator.
Exactly.
This is a tricky area for anyone studying contract law or, prepping for an exam. So I want to boil this down. If our listener sees a similar fact pattern, how should they attack it?
We can condense all of this into a punitive damages and arbitration checklist. It has 4 steps.
Okay, hit me with step 1.
Step 1, spot the forum. First, you ask, is this case being decided by a judge and jury of court, or is it being decided by an arbitrator?
And that's the key fork in the road.
It is. If it's a court, punitive damages might be allowed usually in tort cases, but if it's an arbitrator, you immediately proceed to step 2.
Okay, so if we see arbitrator, alarm bells should be ringing. What's step 2?
Step 2, identify the damages. Look for any award specifically labeled punitive, exemplary, or treble damages, anything that's meant to punish rather than just compensate.
And step 3?
Step 3, apply the Garrity rule. If you have an arbitration plus punitive damages, the combination is invalid.
Just flat out invalid.
Flat out. The reasoning is that it is void as against public policy. An arbitrator has no power to award these, even if the contract says they can.
And finally, step 4, what's the result?
Step 4, the result. On an exam, you must conclude that the punitive portion of the award must be vacated. But, and this is crucial, the compensatory portion usually stands, so don't throw out the whole award, just the punishment part.
That is a fantastic roadmap. It really clarifies that the forum where you're arguing dictates what kind of justice you can actually get.
It does. It reminds us that arbitration is a tool for resolution, not for retribution.
So, what does this all mean for us? I think the big takeaway here is that there are very real limits to what we can agree to. You can hire someone to decide who owes who money. You can hire an expert to settle a dispute, but you cannot hire someone to be the state. You cannot hire a private judge to hand out punishment.
That is the core of it.
Yeah.
The power to punish is a sovereign power. It requires the safeguards of the Constitution, of the public court system. It's just too dangerous to be left in the hands of private actors in a conference room.
And here's where it gets really interesting for the modern world. We live in an economy where arbitration clauses are just everywhere.
Oh, absolutely.
You sign one when you get a cell phone, when you open a bank account, when you get a job.
Yes, it is the default for so many consumer interactions.
So here is a final provocative thought for you to chew on. The rule in Garrity was designed to protect us from barbaric private punishments and coercive economic sanctions. It stops the billionaire from finding the author.
Right, it protects the little guy.
But in today's world, does this rule still do that? Or, by banning punitive damages in arbitration, does it actually insulate bad corporate behavior from being punished? If a company knows they can only ever be forced to pay back exactly what they took and never face a punitive fine in arbitration, do they have any real incentive to stop breaking the rules?
That is the paradox, isn't it? The shield against private tyranny might have become a shield against corporate accountability.
Something to think about next time you scroll to the bottom of the terms and conditions and click I agree. Thanks for listening to this deep dive.
It was a pleasure.
See you next time.